way. So in essence, when we're talking about availability, we are saying it entails the existence of a national supply of food sufficient to meet the nutritional needs of all people in the country and geographically distributed in such a way that it is physically accessible to everyone. Now, very quickly again, acceptability, which generally entails a need to account for non-nutrient-based values attached to food. And additionally, to ensure the proper protection of the right to food, a state is enjoined to ensure food free from adverse substances. This point, I think, has been made in almost all the key elements. And this generally entails that the implementation of the protective policies and laws must ensure food is safe and uncontaminated. Again, I will emphasize the issue of access to information here, especially in the grassroots levels. We need to go down to the village. We need to go down to Eslali and Makaya and talk to people about what is acceptable in terms of what they consume. You know, if you go to dispenser shops, if you go to, all food production places or where food is accessed, does that meet the standard in terms of what is provided for, in terms of that the key content of the right to food? And then very lastly is the key element of accessibility. It definitely refers to, or requires that people be able to acquire the food that is available and to make use of available opportunities to produce food for their own use. This capacity exists if people exercise some entitlement over food or the means of production thereof, wherein they earn an income by selling labor, or other commodities. So the issue of employment and unemployment does play a role here, because when people are employed, then the assumption is they've got access to income and therefore inevitably access to food. But when unemployment rises, then it becomes difficult, because then people do not earn any income, or they cannot sell their labor, and therefore they may have challenges in terms of food accessibility concerned. And if that happens, even those that are dependent on them, such as children, are affected. Now we also see here that in terms of accessibility, the issue of social assistance by the state does play a critical role. So, the timely delivery of, of grants, etc., does play a critical role in terms of food accessibility, because once all the grants are dispersed on time, there are no delays, then the assumption is, or the inference that is drawn is that at least it is possible that at least people have got access to food. And also there's an issue of other forms of legal controls over the means of production, such as land, implements, water, so that at least people can produce food for their own use. And consequently, therefore, the government has national obligations in respect of the right to sufficient food. And these obligations include the obligation to take necessary steps to mitigate and alleviate hunger, even in times of natural and other disasters, including during COVID-19. And where necessary, the state must mobilize international assistance through humanitarian organizations to ensure that there is proper access to food. I don't know how much time I have, but quickly to our own domestic legal framework. I started with that because we're party to all these beautiful international instruments. But then the key question is, do they translate to tangible, rights at the domestic level, especially at the grassroots level? Earlier, someone spoke about the bottom-up approach. I think it may work. To an extent that we need not to have a top-down approach always, but maybe to try and bring a balance of taking these international instruments down to the villages, in different, perhaps formats, to try and see that people are sensitized about their rights. They've got access to information. They know what is expected to them, including children themselves, who are, human rights, of course, beneficiaries, as it were. Now, according to the former Deputy Chief Justice, our Bill of Rights, which is one of the key instruments in protecting the right to food, provides that our Bill of Rights is an eclectic collection of guarantees drawn from international human rights instruments and customary international law, which I spoke about earlier, and represents the most prominent evidence of our subservience to international human rights standards, as it were. Suffice to say that our Bill of Rights does merit special attention, especially in this current context where we're discussing the right to food. And again, we know from Section 7 that our Bill of Rights is the cornerstone of our democracy. So it is the foundation of, almost everything, including, of course, the entrenched Bill of Rights, as it were. Now, in terms of the enactment of laws, the policies, Gabin J, I think it was, in Makwanyan, did say that at least for interpretive purposes, we must refer both to, binding international law and non-binding international law. And that authority comes from Section 39, which says that when you are interpreting any right in the Bill of Rights, every court or tribunal must consider international law, which we spoke about earlier, and of course, read together with Section 233, which provides that we must prefer a reasonable interpretation of any right in the Bill of Rights that is in line with international law over the one that is not. Now, in terms of the Constitution, the right to food is protected in three main provisions, though I'll zoom in only to the one that is related to children. Firstly, at the heart of the right to food in the Constitution is Section 27, subsection 1b, which provides, among other things, that everyone has a right to have access to sufficient food. Secondly, the right to food is guaranteed in Section 28 of the Constitution in respect of children, which provides that every child has a right to basic nutrition, which largely protects the right to food. And lastly, the right to food in the Constitution is guaranteed under Section 35, subsection 2, which deal with the adequate nutrition for the detained persons. Now, when it comes to Section 27(1)b, there is an internal qualification or limitation which provides that the state can only make this right available progressively by taking reasonable steps, etc. Not to say that the state must negate its obligations, but that it cannot be claimed immediately. But however, though, what we see in the comprehensive socio-economic rights jurisprudence, the Apex Court has explained and interpreted the internal qualification to mean that the state stands to give effect to the right to food, and indeed any other socio-economic right must be subjected to a test of reasonableness, and which then ensure that the level of scrutiny, is very high and depends on each case as to whether did the state fulfill its obligations. I always ask some of my colleagues and my friends, especially when we discuss socio-economic rights, to say, how do we balance the failure to ensure that enough resources are channeled towards the realization of the right to food and rampant corruption on the other hand? To me, it becomes, irreconcilable, in terms of how resources then are channeled towards the realization of, of fundamental human rights, as it were. Now, when it comes to Section 28, which protects the right to food for children in this particular inquiry, is that the internal qualification seems to be absent, and it is only present only in terms of the right to food for everyone. The consequence, therefore, is that the efforts of the state to protect and promote the basic nutrition of children will only be subjected to Section 36 limitation to assess indeed if the state has failed in its obligations. And thus it will be difficult for the duty bearers to justify a failure to realize the right to basic nutrition for children than for everyone else under Section 27. In other words, the standard of scrutiny is very high in relation to children. I think for very obvious reasons. They are vulnerable, and of course there must be extra measures to protect them. And in Juma Masjid case, while not so directly related to that to food, the court did find that in an existing right, there is an infringement of the obligation to respect, to protect, promote, and fulfill the rights. And this takes me exactly to Section 7 of the Constitution, the obligations to protect, promote, respect, and fulfill the right to food. Now, the typology obligation, does, at least show us the linkage between the right to food and other, perhaps, human rights. Now, it provides that, in terms of what is expected of duty bearers, is that the state must respect, it must protect, must promote, and it must fulfill those rights. Now, what we see is that these obligations are of paramount importance, especially in this particular context, because all rights, like I said earlier, are interlinked, they're interdependent, and a number of scholars agree that the realization of the right to food must be observed in light of the right to education, the right to healthcare as a significant element of nutrition, which is also a critical element under the adequate standard of living. I will say something here, especially under the right to education and healthcare. When people are educated, they are able to make informed decisions, they are able to earn an income, and therefore they can enjoy the right to food because they've got the means to buy food or even to produce food for themselves. And the same goes for the right to healthcare services, to say that, when talking about, healthcare, there are issues of nutrition, there are issues, etc., and avoiding malnutrition, etc. It becomes then very critical that when these rights are realized, inevitably the right to food perhaps is enjoyed by anyone concerned. As a ramification thereof is the fact that the realization and enjoyment of the right to food both depends on and makes possible the enjoyment and realization of other rights. The right to have access to potable water is one of the direct one, because water is used to produce food, and water is a key element also when it comes to, the right to food. And it is also intrinsically linked with land rights in section, and environmental rights in section 24 and 25 of the Constitution as it were. Now, when it comes to the duty to respect the right to food, the obligation to respect entails the duty not to interfere with the enjoyment of the right to food. The obligation thus requires the state to refrain from interfering directly or indirectly with the environment, with the enjoyment rather of all human rights and freedoms of individuals to use material resources alone or in association with others. During COVID-19, I'm sure you did see a case that was trending at the time, the Equal Education and Others versus the Minister of Basic Education, and all MECs in the 8 of the 9 provinces, wherein the nutrition program in schools was sort of stopped during COVID, and it was only the Western Cape that could proceed with that program. And Equal Education did take the government to task to say that they've interfered with the duty to respect, and therefore the government had failed in its obligations because some children are solely dependent on the meals at schools, on the nutrition program, and it was for that purpose that that program was started by the government as early as 1994 to try and mitigate the issues of malnutrition and to have access to nutritious food by children. Now, I'll talk about retrogressive measures maybe during questions. I will quickly go to the duty to protect. The duty to protect basically enjoins the state to take measures that prevent non-state actors, third parties rather, and sometimes its own entities, such as individuals, groups, and corporations and other entities from interfering with individuals or the group's enjoyment of socio-economic rights. The obligation to protect entails the creation and maintenance of an atmosphere by effective interplay of laws, regulations, and other measures so that individuals and groups may realize their rights and freedom, and in this particular context, the right to food. And Professor Langford does say in this regard that the obligation to protect requires more than just a passage of legislation or laws, but it requires a regulatory system which includes inspection. Earlier I spoke about consumer protection, the prosecution, and other monitoring mechanisms to restrain individuals, corporations, and all other concerned entities from interfering with the enjoyment of socio-economic rights. In this particular case, like I said, will be the right to food. I'm going to jump so that at least I don't waste most of the time. The duty to promote the right to food requires the duty bearers and, of course, all relevant stakeholders to undertake actions that create, maintain, and ensure the realization of socio-economic rights, including the right to food. And the steps taken to promote a particular right will depend on the right in question, but generally involves appropriate education and public awareness concerning access to socio-economic rights. Hence, earlier I spoke about the right to have access to information, that it plays a critical role in the realization of the right to food. There is no way that we can promote the right to food without access to information. And in this regard, it is linked also to the obligation to fulfill. And, perhaps it also includes the mandate, on the state to undertake actions that create, maintain, and restore the realization of socio-economic rights, such as the adoption of educational and information programs designed to enhance awareness and understanding of the right to food. And I think the state is playing a critical role through the commission in this regard to try and reach out to everyone in the province, and grassroots levels for them to have, access to, at least to know their rights, as it were. I'm almost done. And then the obligation to fulfill requires the state to adopt appropriate constitutional, legislative, administrative, budgetary, judicial, promotional, and other measures, including relevant national policies, to ensure the goal of full realization of socio-economic rights to those who cannot secure those rights, through their personal efforts. So it speaks about even issues of social assistance to a number of vulnerable groups. And it also, so it says here that the duty to fulfill is the most difficult and contentious to implement of all the obligations imposed by socio-economic rights. Why? Because it is often difficult to articulate a clear violation of the obligation to fulfill, as it involves the court's evaluation and analysis as to the substantive, adequacy or inadequacy of the government's programs. And any retrogression thereof, will be prima facie a clear violation. And the locus classicus case in this regard is the Equal Education and Others versus the Minister of Basic Education in 2020 during COVID-19, the case that I just spoke about now. Our submission, therefore, is that the government must have a reasonable and clear national strategy to ensure the realization and enjoyment of the right to food, especially by children who, by their very nature, are vulnerable. But again, the issue of implementation comes to the fore. Now, for a strategy to be reasonable, I refer the commissioners and, of course, everyone to the curriculum PEP standard. And of course, we are aware that there is a national policy on food and nutrition that was enacted by the government in 2013. It is very beautiful. I'll jump this slide on this standard, but I want to go straight to the policy to say the policy does, because its main objective is to try and be a guide or a yardstick through which the national, provincial, and local government, must put in measures to ensure food security at every level, as it were. Now, but it does, perhaps tell us some of the challenges that exist. They were true then, they are still true today. Some of them include climate change and altered patterns of land use, which pose a threat, the non-use of land that is available for, food production, the inadequacy of the, access to food by everyone in the province and in the country, etc. And so now maybe to close this discussion is that we've got all the international, national, and perhaps even at the provincial level, some of the policies, the legislative framework, that exist and to give us guidance. The challenge becomes the implementation and the enforcement thereof. And partly when we're preparing here, and of course in some of my studies that I'm doing that are closely linked to this, is that different departments work in silos. Instead of having one comprehensive, perhaps even a task team comprising of different, departments, you've got this department, pursuing that goal, and this department pursuing that goal, and some of the perhaps objectives are more or less the same. So there's redundancy because we could have just met and then say, okay, let's pursue this goal together. Let's put this task team here and sub-task team as it were. So that way it might be easy, at least even for issues of accountability, to say, let's have a look as to what the task team recommended, who is supposed to account, etc. And to conclude, I want to say that the three arms of government do play a critical role, rather, in ensuring the realization of everyone to the right to have access to food, especially children. And any failure by any of these arms may be catastrophic. And any measure that has been put in place by the government must be rational and comprehensive to ensure that there's zero hunger and poverty alleviation, and of course SDG 3 on the highest attainable standard of health. And in this regard, goal number 16 of the SDGs on effective institutions come to play, because the Human Rights Commission plays a critical role in that regard. The courts, do play perhaps a critical role, including in institutions of higher learning, religious bodies, etc. And now, in respect to children's rights to food, it is key that the 4 basic children principles are used as a yardstick through which the national, provincial, and local governments plans are measured in regards to the realization and enjoyment of the right to food. These include the right to life, survival, and development, the right to equality and non-discrimination, lastly, the right to children's freedom of expression. So in other words, when policies are formulated, children must be consulted, of course, taking into account their age, etc. Thank you very much.
Thank you very much, Kacheni. Kacheni, I like you frequently saying, I don't want to waste time, mindful of the time, and you were using the word conclude, I think, for several times. And then you achieved to let us continue listening to you. That was on a light note. But on a serious note, Professor Ndlovu, I heard you loud and clear when you said that a person who is denying climate change is committing violence. Did you say he's committing violence, or what is that person committing?
Yes.
Right. I've got just a few questions for you, Professor. There seems to be a lot of legal instruments that regulate the right to food. Now, there are these 3 questions. What would you say is then the problem in realizing it in South Africa? That's question number 1. And then question number 2, how would the Human Rights Commission play a role in enforcing the right to food? And the last question is, what remedies existing or new, would you provide for situations where the right to food has been violated? On my side, would you please respond to those three questions? Dr.
Ngiyabonga, Commissioner. Maybe to respond to the first one, I think implementation becomes the challenge. That we do have these beautiful laws, we've got beautiful perhaps and well-crafted policies, but implementation becomes a problem. I think it goes back to the point that I made almost at the end of my presentation, that we are working in silos now. But if at least there is, even at the provincial level, as it were, for instance, in the province, let there be a task team comprising maybe of Department of Basic Education, comprising of the Commission, comprising of the Department of Health, comprising of quite a number of all other social development, all other relevant stakeholders, and to see what programs they have that are meant to advance the laws that are there or that are meant to realize that to education. Now, and see if there's no repetition even in some of these. If there's repetition, let's remove that. Let's not waste money. Let's channel money on this one. So now, once there's this well-coordinated, perhaps strategy, even within the province, within the local sphere, or within the municipalities, it becomes easy then to target or even to see where are we lacking, where are we going, where are we improving, where can we improve, or where can we perhaps strengthen our our mandate. To me, that would be maybe something that needs to be done on the first question, Commissioner. And then secondly, the role of the Commission, I think, is very critical, in this regard. The Commission is already doing quite a good job in terms of these inquiries. I think this is my third inquiry with them this year in the province, something that had not happened before. So, firstly, in terms of human rights awareness, the Commission needs to, perhaps try to reach out to the grassroots levels, in terms of the human rights awareness. And they're doing that through the moot courts, the national school moots, in terms of, seminars and advocacy, perhaps measures. Then once people are aware of their rights, it becomes even easier sometimes in terms of what is expected of government, what is expected of them, because the rights are they also have responsibilities. But when people are not aware of their rights, it becomes even more difficult for them to enjoy them or even to claim them. So, and also for the Commission to play an oversight role, to try and check what the department are supposed to do in terms of their constitutional and legislative obligations. Are they doing exactly that? If they are not, then they must be taken to task to say, in this school, the nutrition program has been stopped, or children are not given proper food that is nutritious or that meets their dietary needs. What is happening? So they must take the Department of Basic Education to task, because the department has got that authority to oversee that what is happening in schools is in line with the constitutional, mandate, as it were. And then lastly, in terms of the remedies, I always say that we must avoid going to court litigation. We don't go to court as friends and come back as friends. So, but perhaps it's to try and have more consultative processes to check as to where we are, where we come from, and where we are going. That way, then we can try to come up with certain strategies to see what is working and what is not working in terms of realizing the right to food. And also, I will speak very largely here on the issue of land. The issue of land becomes very critical also in terms of the realization of the right to food. If that process is expedited and people are well equipped and educated in terms of producing their own food, that can also play a critical role in terms of them producing their own food and therefore trying to mitigate, than to say we expect government to do this and do that always, but to try and meet government halfway. So if there's a legislative framework that has been put in place, at least to try and effect Section 25 in terms of access to land, perhaps it could be one of the reasons. But where the government has clearly failed in terms of its legal obligations, I think the remedy will be that we take them to court, at least have a binding, perhaps, remedy as it were, and so that at least maybe it could be something that could be a wake-up call for others that may not be, maybe not channeling the resources properly to where they're supposed to be channeled in this particular context on the realization of the right to food. I don't know if my colleague here has got something. She says she's fine. Commissioner, I'm not so sure if I answered all your questions correctly.
Yes, you have done so. But my fellow panelists would like also to ask you questions.
Thank you, Doctor. I'm going to give you over to Commissioner Makwetla.
Thank you, Doctor. My question is around motherhood and childhood, which are entitled to special care and assistance, whether born in and out of wedlock. But where a mother has not got that motherhood and childhood, who are we entitled to hold acceptable for that?
Thank you, Commissioner. Doctor?
Sorry, Commissioner, I lost you on the last part of the question. Please, apologies for that. If you can repeat the last part of the question.
Yeah, I said, who are we supposed to hold accountable for that?
Okay. If I get the question clearly, Commissioner, thank you so much for the question, is that I think the state, because if you go to all these international instruments, including the Constitution, is that the state must meet at least, families where who cannot provide for themselves. The state must at least mitigate that by, providing for, means, to ensure that socioeconomic rights are realized. In this particular context, the right to food. I'll give an example of maybe children that are staying in state institutions and also maybe in some private institutions. The duty of the state in that regard must not be malicious in terms of just creating institutions and then deserting children. But we must ensure that these children in alternative care also enjoy rights equally to children that are in families. So they mustn't just be thrown there for the purposes of being taken out of the streets or etc., or where motherhood is not forthcoming, but they must be taken there for them to enjoy all other rights in as much as they are in alternative care.
Thank you, Dr. Ndlovu. Just a comment on a question from my side as well. I think number one for me, as I understand it, is that we don't yet have a constitutional court decision pertaining specifically to the right to food. Is that correct?
That is very correct. As I started with that, there's depth of jurisprudence in that regard. In fact, sometime in 2015, together with the Department of Constitutional Development and HSRC, we're trying to check the role of the Constitutional Court judgments and the SCA judgments in terms of their transformation agenda and the realization of socioeconomic rights. But it was difficult to find any direct Constitutional Court judgment in terms of the right to food. The only one that is currently there, I think, is either a High Court judgment or any direct protection through other socioeconomic rights. That's correct.
Okay.
At least to the best of my knowledge. Yeah.
Yeah. No, thank you. So I'm just trying to for context then have a look at the almost the poverty alleviation of efforts by government, Section 27, social assistance, then vis-a-vis Section 28. Because my understanding is that in terms of the social assistance and the relief and the poverty relief efforts by government, one would then assume that the child support grant is an effort by government to potentially address hunger and food issues and food insecurity within the household. Now, we also know that social assistance and the child support grant is seen as poverty alleviation, and I think there's a general acceptance that we know that the grant is not necessarily used in the household for one specific child. It is used in the household as a whole to address the needs of the household. But I'm interested in your views to superimpose that premise onto the direct enforceability almost of Section 28. Where there's no internal limitation clause, where it says that the child has a right to basic nutrition. So it's not like we're speaking about social assistance as in Section 27, which then one would assume the child support grant would flow from a Section 27 perspective, but as a standalone in terms of Section 28 as a basic right that is not qualified. So I'm interested to hear your view on whether that premise can be argued almost, or whether the CSG will be seen to fulfill in the needs of the Section 28 requirement. So what I'm trying to do here is to say, yes, poverty alleviation, yes, the CSG in terms of social assistance, in terms of Section 27, but are we not neglecting the basic requirement of fulfillment in terms of Section 7 vis-a-vis 28 to address basic food requirements of children, and whether that may be something that needs to be addressed separately as opposed to as part of Section 27. And maybe if we look at the Grootboom decision to say that, you know, if parents are not able to fulfill in the needs of the children in housing, shelter, then it becomes the responsibility of the state. But the Constitution calls out food specifically, not necessarily, clothing and care, etc. Food. So I'm just wondering whether I can solicit a comment from you, from the academic point of view, on that superimposition of a direct enforceability potentially of this section, basic nutrition, vis-a-vis the attempts from government in terms of Section 27.
Thank you so much, Dr. Kato, for that, perhaps, as I say, comment question. Mine is to say that if we look as to what the court said in the Grootboom judgment, perhaps we can agree, as I said earlier, that the Grootboom judgment, the Constitutional Court, the Apex Court did acknowledge the fact that, when it comes to children, perhaps the standard of scrutiny becomes very high, because just like shelter and basic nutrition in 28, I always say that if the parents of the children under Grootboom had argued their case maybe under Section 28 and not under 26, perhaps maybe we could have different outcomes, or even a much, perhaps broader judgment, not just perhaps what is provided for now. But, and again, maybe to say that the level of scrutiny that then will be leveled against 28 should be done so, not so much, as a standalone right, but perhaps with Section 27 used, to reiterate the information provided for in 28. So, in other words, Section 28 is a standalone right. Children must be given the right to basic nutrition, and the state must mitigate that, and it's already doing through the child grant. But now the challenge then becomes as to whether that is channeled towards what it's supposed to be done, because like you are saying, there are other challenges, dynamics within, of course, maybe the family environment, wherein that is used for the family, broader family, and not necessarily the child. So a child may, at the end of the day, not necessarily enjoy the key elements of the right to food because of those dynamics. I think that is where, again, we need to say, other than the social assistance, what other means of perhaps food production mechanisms can we take to the citizens, so that at least we can mitigate this perhaps dilemma that you just bring to the fore? Because I can tell you now, I do not have a direct answer as to whether or not that premise should be perhaps followed. But perhaps maybe to make a submission again to say we need to treat Section 28 separately in as much as it is directly linked to other socio-economic rights. That way it might be easy to ensure that the duty bearers, including the state and general guardians and parents, then fulfill their mandate in as far as that is concerned. Only when the families cannot provide for themselves can we then maybe perhaps expect something from the state. And not only because in terms of grants, but in terms of access to land, access to all other avenues that can increase food production, as it were. Doc, I'm not so sure if I respond. My answer is as vague, I think, as it sounds, but yeah.
No. It sheds a bit of light in terms of the thinking as well, that, is there's two avenues of arguing, as you've referred to, either Section 26 or 27, or a 28. And I do think
because my challenge, Doc, maybe my challenge is that, for a very long time, children are treated as an extension of their parents and their families, which is not supposed to be the case.
There we go.
Children are human beings, are full human beings, which are supposed to be treated as such. From the moment they are born, in terms of our law, they are endowed with rights and dignity like all of us. So we should, and I think that's why we've got 28 in the Constitution, because it tries to go to that aspect to say, children are human beings with human rights, and we should channel resources towards the realization of those rights. In as much as they enjoy 27 and all other rights in the Constitution, depending as to their age, etc. But we need to try at least to treat them as full human beings without, perhaps treating them as extension of their guardians or their parents. Yeah, sorry to talk to yeah.
No, absolutely. Your comments are very valuable in terms of understanding this contextually. I think, let me park that one there. My next question would also solicit a comment from you, perhaps. We've got the school nutritional program, which can very actively participate in the alleviation of hunger of children. But we all know that it may only be effective for school-going children. Now, in terms of the research, you've also noted, and I think the previous presentations have made reference to the first 1,000 days of a child's life. That is very, very crucial in terms of development. So between birth and school-going age, then we've got the ECD portion of development. And I know Commissioner Mkhwetla has recently now been again transferred to the mandate of the Department of Education. But do you think that one could then argue that we are failing that portion of children so as to say that the provision of food to them is lacking because they don't partake and they don't have access to the school nutritional program?
I would agree fully. In fact, if you look as to, I think it's general comment that I'm not so sure, general comment number 15, I can't remember, but it does speak about the issue of the nutrition program and why perhaps we should perhaps ensure that perhaps program, covers all children, and it goes to one of the 4 basic principles. In fact, 2 of them: the right to life, survival and development, and then the right to equality and non-discrimination, as it were. Now, my key question, Doc, that I'm going to throw back to you and perhaps maybe to Commissioner Mkhwetla for a comment is, why do we have school-going children not going to school? That shouldn't be the case. The first instance, I understand the concern, but why should we have children that are of school-going age not going to school? I understand there are other, perhaps, challenges in terms of, especially in the province, Twala, etc., where children are taken out of school and all these things. But our key question is, why should we have children of school-going age not going to school? We are failing children in that aspect. Because to me, the right to have access to nutrition in terms of children that are not going to school, falls away the moment we ensure that school enrollment is put, in place. Now, I think to the best of my knowledge, there is a policy that, if you keep a child of school-going age not going to school, I think you might be committing a criminal offense. I need to confirm, that, but I'm not so sure maybe if you are aware of it. But otherwise, we should start by ensuring that all children of school-going age must go to school.
Yeah.
And then to come back to closely to the comment is that I don't see any reason as to why we should have children that are not going to school, they have access to that. But the challenge then becomes, how are they going to access it if they're not going to school? How are they going to be accounted for, in terms of their documentation, who they are, etc. It becomes a challenge, I think, for the Department of Basic Education then to account for them, because it goes to the issues of budget, budget as it were, in terms of planning, Now, if we've got children that are not going to school, now how are they accounted for?
No, absolutely.
To that.
No, you're making very valuable comments, Dr. Ndlovu. Thank you for that. I will give to Commissioner Mkhwetla in a second to maybe comment on what you have said. I think maybe this is my last comment or question to you. You've made reference to the SERAC judgment, the Nigerian judgment, where it says that there's also an obligation not to destroy food sources. So if,
Yeah.
and I know you've tuned into the previous presentations where it has been mentioned that about 30% of all food produced within the country, and which is still usable, lands up in landfill sites. Now, in your view, would one have a premise to argue that food that can be consumed still in a country where children are dying of hunger, and where that food is then being destroyed in landfill sites, maybe as a result of some supply chain management operations I'm not conversant with as yet. But would you argue that, or would you see an argument relying on not destroying food sources being relevant in the case where we are throwing 30% of food produced in the country into landfill sites?
All right, thank you so much, Doc, for that. I would say that the very first thing that we must maybe agree on is that there's no way that the state won't interfere with any of our rights, including the right to food. But can the state justify the interference thereof? And again, we need to check that if food is destroyed, was it because of some state projects? Was it because of third parties, but that has been given acquired by the state? If that is the case, then we need then to hold the state accountable, because again, how do we balance the children? When I read the invitation and then I went to the internet, I checked the the states that they provided. I was heartbroken, to say the least. To say then, how do we balance on one hand, destruction of food and food production maybe places, and on the other hand, with issues of malnutrition and the lack of food and the hunger that is still being faced by quite a lot of children, especially in the province. Now, we saw from the previous presentation that currently 2 provinces, are food insecure. That is us here in the province, and of course, the Limpopo province. Now, so if we can also establish as to some of this destruction of food production mechanisms that are taking place, my assumption is perhaps maybe they are taking place in some of these provinces. Now, what should be done in that regard? Hence, I talked about the issue of accountability and holding the state accountable. We need to come to a place where we're saying we understand the right to development. We understand some of the developmental needs because it's part of the SDGs as well. But on the other side, are we not then prioritizing development over food production and of course food security? Because that's what transpired, I think, in the Sarak judgment. And of course, there's a Kenyan judgment also by the commission. I think it's the in the Ogoni land or something, wherein the company was given the right to go and mine and do all sort of things and destroy the forest, which was producing some of the food for the locals at at that particular place. So there need to be to be a balance between, on the other hand, development projects and of course with the non-interference with current food perhaps production, as it were. Because once we fail there, then we'll end up with this 30% of food that is lost as a result of the failure to balance. Hence, earlier also I spoke about that we are working in silos too much, which then becomes problematic. So if, for instance, the Department of Public Works, the Department of that, or whatsoever Department of Mines comes to the fore, or to the party as well, in this task team, at least in mind, then you'll have all of us say, okay, we are planning this. But now for us to do this, maybe let's wait for the harvest to finish. And once the harvest is finished, then we can see what other alternative land can be given to people to farm to replace that. Because then once we fail in that equation, then of course we'll end up with a situation whereby quite a lot of children then malnutrition because of the lack of food. And of course, proper accountability mechanisms to ensure that what is intended for children gets to the children. It doesn't end in somebody's pocket or doesn't end somewhere, but it does reach the intended purpose, as it were. Because we saw this during COVID-19, that food parcels, some of them did not reach their intended purposes. I mean, on the news, etc. It also contributes to all these things as to why we may end up in this dilemma, Doc, as it were. Thank you so much.
Thank you, Dr. Ndlovu. I'll pause there and potentially give Commissioner Makwetla an opportunity for a comment on your comments made.
Thank you, Doctor. In a position where mothers are not in a condition to send the child to school, the children should be taken away from the mother, as the case might be. and then to hand them over to a child care center. But we know that the child care centers come with a lot of responsibility, a lot of commitment. So, you know, it is mind-boggling. It's such a condition of responsibilities that the authorities have.
Thank you. Absolutely, Commissioner. I think that there's so many, I mean, that level of conditions that the homes must comply with, also then to access the grants, so that they in turn can then fulfill the duty of the state in loco parentis almost, when the parents are unable to do so. One would have to have a look at that as well. And that is exactly why we have also invited SASSA, DSD, etc., and also various children homes to the table to come and discuss their concerns as well. Commissioner Sibanyoni?
Very briefly, Kacheni, I heard you loud and clear when you were making a call for not working in silos. And I must say that the Human Rights Commission does work hand in glove with some civil organizations, except those who do both civil and political rights, because as the Human Rights Commission, we are not an institution that can be involved in political rights, but in civil rights, yes, of course. And then also, I've heard you when you were saying that it is better for consultative measures because taking matters to court for litigation, people don't come back friends. And I must say, as the Human Rights Commission, I often say we are being referred to as a watchdog on human rights. And to use an analogy of a dog, we've got barking powers as well as biting powers. We start with the barking powers, consultative measures, and we don't go straight to the biting powers thereof. And then, but what I would like you to comment on, is there any harm when the Human Rights Commission works hand in glove with civil societies that are dealing with human rights or the violation of human rights? Thank you very much.
But let me start maybe with Commissioner Makwetla's comment that I do fully agree. In fact, I'm writing a paper with a colleague on that particular aspect as to whether children in alternative care are actually enjoying the right that they're supposed to. In other words, whether Section 7 is fulfilled in that regard. And perhaps maybe one of our recommendations is that the institutions of care should be as a means of last resort. We should try and check maybe, interfamily, adoption, etc., and see what is working and what is not working to try and ensure that we're not malicious in terms of just the Constitution says there's a right to alternative care when the care cannot come from the mother or the father or the family. No, that indeed a child in alternative care and a child in a home environment or in a family environment are the same. In other words, they are all equal, treated the same. They have got access to resources. Now, but to come to Commissioner Simanyon's point, I don't think there's any harm at all. In fact, I think in terms of what, the realization and enjoyment of human rights, what the Commission is doing to work with NGOs, to work with, faith-based organizations, that are keen about the enjoyment of human rights. That should be, the way forward, because some of them come with resources, some of them come with advices, some of them come with knowledge. In that way, the goal becomes the same. Then we are able to achieve the enjoyment of all rights, especially the rights of most vulnerable groups, such as children.
Thank you, Dr. Ndlovu and your team for the valuable input you've provided to us. We have certainly, grown a lot as a panel in the past few hours, and your information from a legal perspective and the framework you've provided is definitely helpful in that regard. So we are thanking you and excusing you, but we do hope that you keep on tuning in for some very crucial information that will be forthcoming throughout the day and the week. So thanks so much.
Yeah, well, cool. Thank you so much for the invite.
Tembe, I think if we can proceed with Stats SA. All right, so, there's just joining us in person, and then there's a colleague online. But the colleague wants to join. All right. Ms. Patricia Koka, the Director of Multidimensional Poverty Statistics from Stats South Africa, from Pretoria, connected via Teams, and her colleague will be joining us in person. My understanding is, Ms. Koka, that your colleague will only be here to support the presentation you're going to deliver online. Is that correct?
That's correct, ma'am.
Okay, just I'm going to hand you over to Commissioner Sibanyoni to administer the oath.
Okay.
Ms. Patricia Koka, I'm going to inquire from you whether do you have any objection towards taking the prescribed oath? Because if you've got an objection, we can ask you to make an affirmation.
I have no objection, Commissioner.
No objection.
For the oath.
With an oath, okay. Will you then, for record purpose, state your full names and surname?
Siopa Patricia Koka.
Right. Do you swear that the information that you will give shall be the truth, the whole truth, and nothing but the truth? If that is the case, please raise your hand and say, "So help me God."
So help me God.
Thank you very much. Thank you very much. Then you can proceed with your presentation.
Thank you, Commissioner. I will then project my presentation. Can you see something on your screens?
Yes, we can see child poverty in South Africa, a multiple overlapping deprivation analysis.
Thank you so much. If you look at the bottom, this work, the report, was a collaboration between Stats SA, United Nations Children Fund, as well as SPRAY. So before I go deeper into the presentation, I just want to, give acknowledge UNICEF in the part that they took in this report in capacitating Stats SA with regards to this analysis called MODA. They made sure that they get external experts to come and train us on how to do analysis on the MODA, how to interpret the results, and how to write the report. So now the country has got some expertise now that with regards to child MODA that can run with, and then all thanks to UNICEF. Okay, I'm going to cover in the presentation the purpose of the report itself on child poverty in South Africa, the data source that was used to produce the results, the methodology, how did we came to the results, and the findings. In brackets I had indicated limited. Because of time, I did not put all the findings, but I just selected a few for the interest of time, and then I'll take you through the conclusion as well as the recommendations. So basically the report seeks to provide the insight on child poverty in South Africa using the multiple overlapping deprivation analysis methodology. So this methodology provides information on multidimensional child poverty levels in South Africa, the main contributors to the poverty situation of children in South Africa, and the socio-economic and geographic characteristics of poor children in the nation. The data source used was the Living Conditions Survey. The data source used was the Living Conditions Survey of 2015. Though it's a bit old, we are now in 2022. I'm glad to share with everyone that we are currently busy with a similar survey that we call the Income and Expenditure Survey 2022-23 that will be in the field in November of this year. So this living conditions survey, like the one we're going to be conducting in November, they are all household-based survey conducted by Stats SA to measure poverty in the country. And we are saying more than 25,000 households participated in the survey. So we have gotten the results from more than 25,000 households throughout the whole nation. So the living conditions covered a whole lot of things that include detailed income and expenditure, education, housing, social welfare, health, and living circumstances. So the methodology, this report has adopted the MODA methodology developed by UNICEF, and there are 4 distinct characteristics of the MODA regards to children. So for number 1, the methodology takes a child aged 0 to 17 years as the unit of analysis. As Professor Ndlovu had indicated, that children should be taken as human beings, not translated to be under the umbrella of parents. So this mode acknowledges the methodology that we should be looking at a child as a unit of analysis. And then this methodology adopts sort of a life cycle approach that reflects different needs of children in their various stages of development. We acknowledge that from 0 to 4 years, we do have early childhood, and their needs will be different from the other stages, which are the primary childhood that looks at children aged 5 to 12 years, and then the adolescent stage or phase, that is those children aged 13 to 17 years. So this methodology, it recognizes the multidimensional aspect of child poverty. So it is looking at the number of deprivations that a child experiences, and also their intersection, meaning where they overlap, rather than on a single deprivation in isolation. So it also looks at the average depth of the deprivation among these deprived children. And also it identifies the geographical and socio-economic characteristics of the most vulnerable children in South Africa. I think Mr. Ndlovu indicated that children, by their nature, they are very vulnerable. So this study is going to take it even more deeper. It will not only be children, but looking at poor children in South Africa. So how the dimensions and indicators have been selected, these building blocks to this South African MODA. So in selecting the dimensions and the indicators, this was guided by consultations with the relevant government departments, and of course the available data at our disposal to make use of, and as well as how good the data is, how good is the quality of the data that you're going to use for the analysis. So these factors, they actually assisted in ensuring that the dimensions, I'm sorry, let me just, I wanted to minimize and something happened, I don't know. Okay, yes, the factors above assisted in the ensuring that dimensions and indicators are relevant to each age group and their selection. So we'll quickly go through the 7 dimensions and their respective indicators that were used for putting together MODA for South Africa. We have an acronym that is well known in MODA as WASH, that talks to sanitation, waste disposal, drinking water source, and this dimension and indicators are applicable to all the age groups. And then we have housing. So I do have a report that covers everything. You know, here is just a summary of what is in the report. So with regards to WASH, it will indicate that a child is deprived in that particular, like sanitation, if it's still using the unimproved sanitation, and it will explain in detail what unimproved sanitation is. And then when we're looking at housing, shelter is an indicator, which also the deprived child will be coming from a household, which its materials that are used for roof, walls, and floor are rudimentary. So the report has got everything in detail. And then looking at the energy as one of the indicators under housing. And then with nutrition, we have indicator food security applicable to all age groups. And we've got protection with an indicator of safety, and then applicable to all age groups. And then we've got health dimension with distance to healthcare center, as well as availability of road to health card, which that particular last one is applicable to 0 to 4 years, and the rest to all the age groups. And we've got information as a dimension, and indicators in relation to that are access to information devices that are applicable to all age groups. And then we've got child development, which is only applicable to 0 to 4 years age group. And then it looks at indicators child development if a child has been exposed to ECD, or for those ages 0 to 2 years, and early childhood education attendance, that is applicable to those aged 3 to 4 years. And education, which is applicable to 5 to 12 years and 13 to 17 years. School attendance. Prof. Ndlovu indicated why in South Africa do we have school-going age children, but not in school. So this is one of the input towards the MODA analysis. And as well, we have lateness in schooling, meaning a child did not complete a grade required for his or her age. For instance, if a child, according to South African Schools Act, a child that is age 9 should have at least completed grade 3 or grade 4, for instance. And you find that in this case, lateness in schooling, a child is still 9 years, but is still in grade 1. So those aspects, indicators, are brought into this pool when we do the MODA analysis. And we look at school facilities. I think it was also mentioned the school nutrition program. So school nutrition program, it's one of the aspects that are included under the school facilities. So I just want to drill down to one that talks to nutrition, because that is the key title of our inquiry for this workshop. It's nutrition. Under nutrition, we have an indicator, food security, and that food security, we are saying it's food inadequacy for child deprivation. It refers to a child from a household that experienced 2 or more of the following 8 questions, which are sourced from the household food insecurity access scale. So a child should have come from a household that ran out of money to buy food, that cut the size of the meals because there was not enough food, that skipped any meals because there was not enough food in the house, or that ate small portions and less variety of foods that they would have liked to eat because there was not enough food. And all these 4, they should all have happened to this household for 5 days or more, 5 or more days in a month. So it has been spoken about by Prof. Mutendwa that South Africa in general, we are food secure. And of course, this is affirmed by results that we get from the General Household Survey. The numbers ranges from 60% food security up to 90+ percentage of people or households in South Africa that are food secure. But when drilling down to the vulnerable, now the children, and taking them to a lower level or another level of poverty, then we find that the numbers are a bit higher. So the analytical approach of the MODA. So we look at a single deprivation, meaning we will look at each dimension, for instance, health, and say for those aged 0 to 4, how many or what is the proportion or a percentage of those that are deprived within that particular sector. So that's a step number 1. And step number 2, deprivation count analysis. So here we counting, MODA is affording us to count in terms of health, in terms of all other education and the rest, how many of those dimensions are the children deprived in. So that's step number 2. And step number 3, it's where it shows that children are not only deprived in 2 or more, but these deprivations, they are intersecting, they are overlapping. So they happen to children at the same time. And then from there we have what we call multiple deprivation analysis measures, which are the head count, intensity, and adjusted head count. We'll look at them briefly in the next slides. And then there is a disaggregation of the results by child monetary poverty. So here we are looking at multidimensional poverty and the child poverty, where they intersect children that are both money poor and multidimensionally poor. So this is the analytic approach that the MODA follows. So the message on the results, as I had indicated, we're only looking at children aged 0 to 17 years and disaggregating all the results according to each stage, as I had indicated previously. So what we have found is that the results indicate similar patterns of multidimensional child poverty status across all age groups, analyzed by demographic characteristics, geographic location, and living circumstances. So here I had indicated that we have got 3, but here we're just going to look at 2. So when we say a child is multidimensionally poor, it's a percentage of children that are deprived in at least 3 of the dimensions. Remember the dimension of health, of nutrition, of education, the 7. So meaning this child is deprived in 3 or more of those. And then we see that the estimate is 62.1% of children in South Africa that are deprived in 3 or more of those dimensions that I have taken through in the earlier table. And then we have what we call the intensity of multidimensional poverty, child poverty. And then here we're talking about an average number of deprivations. How many of the deprivations expressed in a percentage form are these poor children suffering from? So it's 57.4% in South Africa. So here is just to show across all age groups the multidimensional poverty, where the children are deprived in 3 or more of the dimensions. We see them that they are quite high, looking from 0 to 4 years, around 60%, approximately 60%. In the following 5 to 12, 63%, and then 63% for 13 to 17 years, and all children in South Africa, as indicated in the earlier slide, that 62.1%. And also we see that the intensity of poverty is quite high at 56.9%, close to 57% for 0 to 4 years, and so forth, 57 sort of base percent for the rest of the age groups. And then I had indicated that we are not only looking at individual dimensions or sectors, but we look at the number, how many of the dimensions are the children deprived in. So we say once the child is deprived in 2 or more, then they are multidimensionally deprived. So we see that for the children in South Africa that are deprived in none of the dimensions, that's 0, is 5.5% of the poor children. And then those that are deprived in 1 of the 7 dimensions is 13.3%. And then from 2 to 7, that's when we call the multiple deprivation. So we're saying when you add the percentage from 2 to 7, you'll get about 82.1. So we're saying 8 out of 10 children experience multiple deprivation in South Africa. So meaning number of deprivations, they are greater than 1. So now we go to the major contributors. For children aged 0 to 4 years, so major contributors, what it means is that which of the indicators are contributing to the poverty situation of the children in South Africa. For 0 to 4 years, the major contribution for the poverty situation in that particular age group is the green, which is housing. So meaning that those children that are still living in households with houses that have got walls, roofs, and floors that the materials used are rudimentary, not permanent. So that situation is contributing, that particular dimension is contributing more to the poverty situation of the children aged 0 to 4 years. And then for 5 to 12 years, we see 22.1, which is the same with 13 to 17 years, 22.7, and it's a gray, it's education. Remember we said 5 to 12 years, 5 to 17 years is education, and then 0 to 4 is early childhood development. So for 22.1, the gray part, for 5.5 to 12 years, and then 13 to 17 years, the gray part, that particular dimension, education, is contributing most to the poverty situation of the children within those age groups. And then this means that these children, as Prof indicated, they are of school-going age, but they are not at school. And then lateness in schooling, the age of a child is not corresponding with the completed grade. So if you look at the nutrition, you see that nutrition is one of the least contributors to the poverty situation for the children in South Africa. And then here is just to show that poverty affects a male child and a boy child and a girl child equally. There is no like a significant difference to say. We find that a girl child is more poor than the boy child. No, they are affected by poverty equally so. And then we see that here, when we're looking at the disaggregation by population group, we see that Black African children are more likely to be multidimensionally poor as compared to other population groups at 68.3%, with the whites at the lowest, 5%. And then in terms of geographic location of poor children in South Africa, looking at the provinces, we see that Limpopo and Eastern Cape and KZN actually are the three top provinces that have children that have high pockets of percentages of multidimensionally poor children. Looking at the living circumstances, the report is telling us that the children that are double offense, meaning mother and father not alive, and the single offense, either mother or father is alive, and only where mother is alive, we see higher rates of multidimensional poverty within those three categories. Double offense, no father, no mother alive. Single offense, either one of the parents alive, and only where mother is alive, we see highest level of poverty rates. And then we see on the other hand that non-offense have the lowest rate of multidimensional poverty at 59.5% compared to the others. And then now we come to the, I call it the crux. My team knows in the office that I love this part, because this part is actually telling us about MODA itself, the multiple overlapping deprivation. So it looks at each dimension. Here I just chose 13 to 17 years. The interpretation is the same for 0 to 4 as well as 12 to 5 to 12. I just chose this one for the sake of just explaining what these graphs mean. So let's look at nutrition. So it takes nutrition and then shows, you see that it's written deprived in this dimension. Only the percentage of children that are deprived in this particular dimension. It says deprived in this dimension plus one other, meaning the children aged 13 to 17 years, 4.6% of them, they are deprived in nutrition or any other. It can be or protection or wash. And then as we go up, it shows that deprived in this dimension plus two other. So it means 7.7% of poor children